Let's talk about parallel civil and criminal tax exposure. How one mistake can trigger both at the same time. Most taxpayers mistakenly believe with the IRS they're dealing one problem at a time: a civil audit, a tax assessment, a request for information. But what many don't realize is this: a single tax issue can expose you to both civil and criminal risk at the same time. And the danger isn't always associated with the numbers. It's more about how you communicate, what information you submit, and who you speak to first, and really who you allow to speak for you. So, what's this hidden parallel track all about? Here's what actually happens behind the scenes. The IRS and many state agencies often run parallel civil and criminal evaluations. Up front, you may only see a civil examiner, but your file may have already been reviewed by criminal tax investigators who are clandestinely watching in the background. They're not deciding guilt yet. They're really just asking one question most of the time: does this taxpayer's conduct suggest criminal tax intent? So how do civil audits turn dangerous? Most criminal tax cases don't start off criminal from the get-go. Often they start off civil. Then mistakes happen along the way by people who don't know what they're doing. Late responses, aggravating people, contradictory explanations that don't make sense, oversharing of documents, emails that create a damaging record, or the most common mistake by taxpayers, allowing non-privileged professionals to communicate freely with the government. Each interaction potentially builds a criminal intent narrative. And once criminal intent is inferred by the government into your fact pattern, the rules of the game change completely. So let's talk about the communication trap. One of the most dangerous moments in any tax controversy is communication. It's what you say or how your representative talks to them, how you say it, and who says it for you. Statements made casually can later be interpreted as criminal tax admissions. Draft returns, tax planning, emails, work papers. Once these documents are created, they don't disappear. And anybody that doesn't have attorney-client and work product privileges, that information can be subpoenaed. It can become evidence of criminal tax intent. This is why CPAs, EAs, and CTEC certified preparers alone can't protect you. Listen, CPAs are excellent with numbers. I'm a CPA as well as an attorney. But CPA communications are not protected. Neither is their work product. If your case escalates civilly or criminally, your account could be subpoenaed. Their files could be seized. Your emails with them reviewed. And when pressure rises on that preparer, that CPA, they may try to protect themselves first by throwing you under the bus. They don't want to lose their license over you. They don't want to be in a jail cell next to you. That's how well-meaning CPAs, EAs, and CTEC certified tax preparers turn into government evidence of criminal tax intent. Criminal exposure. Okay, how do you manage parallel civil and criminal exposure? When civil and criminal tax exposures overlap, everything must be coordinated. Timing matters, strategy matters, silence can matter. You must control information flow, written records, explanations, legal positioning. Listen, the goal here is simple: resolve the civil issue without igniting underlying criminal tax exposure. That requires legal judgment, training, education, experience, and not just accounting accuracy. We're specially trained to do this work. Why hiring a dual license representative matters. This is where a dual licensed tax attorney and CPA such as myself becomes essential. What do you get? You get attorney-client privilege. You get work product privilege. You get controlled, private accounting work. You get coordinated legal strategy. You get civil resolution without criminal tax escalation. That's the whole ball game. Listen, few professionals can manage both sides of this equation. Not many are trained for it. But when your liberty, livelihood, net worth, and reputation are at stake, you can't afford anything other than top-shelf representation like the tax law offices of David W. Klossing. So, in closing, if you're under audit, criminal tax investigation, or facing any unresolved high-stakes tax issue, don't automatically assume your problems are just civil. And don't try and guess your way through it. Before your criminal tax intent is inferred, before the criminal tax narrative hardens, speak with an experienced criminal tax defense counsel, such as myself. At the tax law offices of David W. Klossing, our dual-licensed tax attorneys and CPAs are uniquely equipped to manage parallel civil and criminal tax exposure. Call 1-800-681-1295 or visit klossingandassociates.com to schedule a confidential, reduced-rate initial consultation today. Thank you.